I'd like to ask the judicial panel to come on stage now so we can begin our first full panel session. The panel will be moderated by David Horrigan. David knows judicial panels. David knows e-discovery. David knows the judiciary and has done a yeoman's job at Relativity as their legal counsel and educational director. So David, with that, I'd like to turn the judicial panel over to you.
Professor Hamilton, thank you very much for the always kind introduction. And this is the first judicial panel I have ever moderated wearing headphones. Because although Judge Matthewman said we should all look good when we appear on camera, I am thinking that what our audience needs is sound quality. And if I look like a Martian, so be it. It's an extreme honor and privilege to return to my alma mater with a group of judges who really go across the board on various issues, and it's been a big year for Florida in e-discovery. Judge Matthewman has issued 2 decisions that have really received a lot of attention. One of them, EEOC v. M15100 Corp., the Jumbo Supermarkets case, was a big one on self-collection. Also, Judge Jones has had a big one this year in the 3M case, which may be the largest multi-district litigation matter ever in our nation. We have a bunch of fine judges here today. Some of them you all know. Customarily, there would be a slide for each one of our judges where I would take the time to introduce them to you because I think it's important for all of you to get to know their backgrounds so you can get to know what their perspectives are, why they may have ruled a certain way, and the perspectives they bring to the case. We have 50 minutes today. It's a little bit shorter than we've had before. Also, many of our judges are returning to us from previous judicial panels. We do have a new justice with us today, and that is the Honorable Julie Snead. Judge Snead is from the Middle District of Florida. I'll give her a little bit of introduction because she's new to the judicial panel. She has clerked for judges in both state and federal court. She is a United States Magistrate Judge for the Middle District of Florida. She was formerly a commercial lawyer. Judge Snead, you're our newest member. I wanted to welcome you first to the judicial panel.
Thank you. It's an honor and pleasure to be here. Thanks for having me.
Absolutely. Thank you for being here. The rest of the panel you see on the screen now. You've got Judge Barksdale, Judge Jones, Judge Matthewman, and of course Judge McCoy. And I encourage you to find their bios at ufediscoveryconference.com, giving you the full details on what they have done throughout their lives in the judiciary and beforehand, because as I said, that really has a lot to do with the way that they can judge cases and be the impartial jurists that they are. We have former litigators, former law enforcement, former criminal defense, as Judge Matthewman pointed out. So without further ado, we're going to go in a different order than we have in the past. Ordinarily, you'd have poll questions later on during the presentation. We're going to start off with a couple of poll questions because we, number one, don't want to skew the data. We don't want you to hear the judges and say, well, the judges said that. I think that's probably right. And number two, the judges really want to hear what you feel about some of these issues. So if we go to our first poll question, that one, it will be coming up on your screens. And I think the university is putting that up. Do we see the poll question? And that actually is not the one. Tell you what, the first poll question is, how has cooperation and discovery increased since the 2015 amendments to the Federal Rules of Civil Procedure? Do you agree with that? Do you disagree? Are you unsure about that? And we'll give some time. All right. Let's go on to the second poll question, and that second poll question.
David?
Yes, sir. Thank you, Bill.
I think we'll just have the audience kind of mark it down in their own minds and maybe ask the panel afterwards. We have a little bit of a technology glitch here, so the polls are not going to come up on screen for the audience.
That's perfectly fine, Bill. So the second one was going to be about how active judges should be in e-discovery. And so we can discuss this. I'm going to bring the judges back onto the screen in full screen because we've got two issues here. Cooperation has been discussed since the 2015 amendments to the Federal Rules of Civil Procedure. Judge Matthewman alluded to that. And we've got the second thing on how active judges should be in the e-discovery process. That is a question that has really been something that Judge Matthewman discussed in his article. Judge Peck, who many of you know from the world of e-discovery, wrote a response to Judge Matthewman's article. I wrote one, and Professor Hamilton did as well, when we're discussing how active judges should be in the e-discovery process. So when we think about that, let's turn and discuss this, whether or not, just how active they should be. Judge Snead, if I can start with you on this one. We've had discussions on whether judges should be actively involved because, frankly, Chief Justice Roberts called for it when he was issuing his year-end report in 2015. Judge Matthewman in Core Component 10, I believe, calls for it. What do you think? Are there any limits to how active judges should be?
I do think it's helpful for judges to take an active and proactive role in helping the parties move their case forward towards a trial or a resolution. It remains the lawyer's case, however, so we're here to assist, but not certainly take over the course of the case. I'm proactive in terms of helping the lawyers move their cases forward. I have monthly discovery status conferences in cases that I identify are particularly contentious, if I'm seeing a lot of motions to compel in particular cases, or if a case comes in and I realize, and having reviewed the docket, understand that this is a particularly complex case. So in those cases, I absolutely will be proactive, set discovery status conferences regularly, even if there isn't a motion. And also, whenever there is a motion, you all may know that in federal court, you're not really automatically going to have a hearing set in your case. But in discovery motions practice, I do find that it's helpful to go ahead and set those motions for hearing. It gives the lawyers an opportunity to come before the court, to discuss their issues, and gives them a chance to kind of meet face to face once again to talk about the issues that they are having in dispute. And I also like to have the lawyers go through each of those discovery requests. And, you know, sometimes if you have 50 discovery requests and you're having to go through all of those discovery requests, I think you tend to think, let's back up and let's sort of see where we can compromise. And then I think it forces the parties to really reach an agreement among themselves. But I do agree, judges do need to be proactive, and we do need to cut off discovery when it appears that there is some sort of fishing expedition going on in the case.
Judge Snead, I'm going to stay with you for a moment, if you don't mind, on our next one, and that's on this second concept of cooperation. Cooperation is something that has been tough. Judge Waxy for years said that the idea that we have to be zealous advocates really, for the most part, got thrown out in 1983 with amendments to the Model Code. We've got combating counsel going back and forth. How do you see cooperation in your court?
I'm really fortunate, I have to say. You know, in federal court, we do see lawyers who understand that they need to come to federal court prepared, professional, and with the spirit of civility and cooperation. So generally speaking, the lawyers really are cooperative. I don't see very many of those nasty letters attached to different pleadings. In most cases, I really don't see those. And I think lawyers are savvy enough to know at this point, most lawyers are, many lawyers are savvy enough to know that that really can backfire. It really can impact their reputation before the court when they're attaching all of those nasty letters and they're not acting in the spirit of cooperation. Also, I'll tell the lawyers out there that as a judge and also having served as a law clerk, I've seen a lot of these discovery motions. And I've also seen it on the side of the practitioner. As you mentioned, we all practice law for a number of years. But on the judicial side, it's very difficult to understand exactly who the obstructive party is. So you can attach all of these letters. You can, make your argument about, the fact that somebody else is not the cooperative person. But as the judge and the decision maker, it's difficult to know if you really are the perpetrator or the person that is being obstructive. So it's better to be cooperative, to try to reach an agreement, to explain what the true objections are, if you have any, and what the true issues are in dispute. We also, of course, have local rules. Every court has local rules. It's important to read those because our local rule does require, it sort of imposes a spirit of cooperation. Lawyers are required to meet and confer before filing any discovery motion. It really needs to be a very fulsome discussion that occurs before a discovery motion is filed. And then once you get in court, there's also a rule that requires that lawyers refrain from any animosity. It may seem odd that we need to impose that requirement of civility in the local rules, but there it is, just as a guiding post to help the lawyers. But I do think there is a spirit of cooperation and civility. There's the rule to back it up, and I think if you care about your reputation, you also want to be acting in the spirit of cooperation.
Thank you very much, Judge Snead. Judge McCoy, in Avista Management, Judge Presnell issued an order. In that order, he noticed the parties could not cooperate. And he said, the court will fashion a new form of alternative dispute resolution. To wit, at 4 p.m. on Friday, June 30th, 2006, counsel shall convene at a neutral site agreeable to both parties. If counsel cannot agree on a neutral site, they shall meet on the front steps of the Sam M. Gibbons U.S. Courthouse. Each lawyer shall be entitled to be accompanied by one paralegal who shall act as attendant and a witness. At that time and location, counsel should engage in one game of rock, paper, scissors. The winner of this engagement shall be entitled to select the location of the 30B6 deposition to be held somewhere in Hillsborough County during the period of July 11th to 12th, 2006. This little incident sort of wraps up two of our themes here, cooperation and just how active judges should be. The new paradigm, core component 10, is calling for active judicial involvement. We've also got cooperation being called for. Judge McCoy, what's your take?
Well, I'm not going to comment specifically on that method used by Judge Presnell, except that as you were just describing it, it reminded me of the duel scene in the stage play Hamilton. It sounded very dramatic. I'd like to address first cooperation. I'd like to emphasize what Judge Snead stated, that cooperation is a baseline expectation from the perspective of the bench. Certainly in the Middle District of Florida, and I'm sure that my colleagues in the Northern and Southern Districts of Florida would agree, the Civil Discovery Handbook for the Middle District of Florida, in the very first section of that publication, states that discovery in this district should be practiced with a spirit of cooperation and civility. And that sentiment is repeated later in sections of the handbook that relate specifically to the conduct of electronic discovery. The reason for this baseline expectation, I think, should be obvious to everyone. And my colleague Judge Matthewman said it perfectly in his New Paradigm article, that, quote, hostility and lack of cooperation unnecessarily increased costs and attorney's fees, as well as greatly delay the prompt and efficient resolution of the case, end quote. I would add to that that it also seriously undermines judicial economy, and I really can't emphasize that enough. There are only so many hours in the day, and judges have, as we all know, many important constitutional and other duties that they have to perform. And I also think when we're talking about cooperation, we need to address the proverbial elephant in the room, which is, in my view, that cooperation means different things to different people. For judges, it's always judged with the benefit of hindsight once a dispute is brought to the court, and the judge can assess whether the judge believes adequate cooperation was part of the process. But as we all know, for those of us who have practiced in the e-discovery area in private practice, cooperation can mean something very different if you're the party responding to discovery who has the vast majority of documents that are going to be relevant to the issues in the case. In many cases, for example, there's an individual plaintiff who's not going to have a lot to contribute on a discovery front, but there may be a corporate defendant who has a great deal of ESI that's going to be relevant in the case and needs to be produced. In that dynamic, the defendant who has the documents feels that the concept of cooperation is applied asymmetrically, meaning it's more heavily weighted and requires more of the defendant. As I've shared in prior conferences, I think that just requires parties who are in that position to be comfortable being in that position and to nevertheless embrace the spirit of cooperation. On the active participation of judges, I want to go back to emphasizing again that judges have a limited number of hours in the day to do what they do. I don't think any judge appreciates an unnecessary discovery dispute that takes their time away from other important duties like taking guilty pleas, holding hearings on motions to suppress evidence in criminal cases. The practitioners who are participating in today's conference spend their entire day immersed in civil discovery issues, I'm sure, but magistrate judges in particular have an entire array of other duties that I think are underappreciated by members of the civil bar in any event. Because of that, I don't think it's practical at all to say that federal judges have to or must or should take an active role in the management of discovery generally in all cases. For example, at any given time, I have between 400 and 450 active pending civil cases on my docket. The idea that I can actively manage discovery in its entirety in all those cases, given the limitations and resources that the judiciary has, is simply not practical or realistic. I think you can do more than simply be reactive when a discovery dispute occurs. Using the discovery status conferences that Judge Snead mentioned is extremely helpful, but also upfront in the case after the parties have completed a Rule 26F conference. Rule 16 gives the court the opportunity to hold a scheduling conference to pull the lawyers into court to ask the questions, about those topics that should have been discussed during the 26F conference, which is the point at which I believe a judge can really get his or her arms around the complexity of the case and whether there's likely going to be a lot of discovery issues, and then flag that case, at least in terms of the court's awareness, for more detailed treatment going forward through discovery statuses or similar proceedings.
Thank you very much, Your Honor. Judge Jones, we've discussed before that Judge Peggy Lean has said that United States magistrate judges are not the Maytag repair reps waiting around for something to do. You are busy people, and at our data discovery year-end review at Relativity at the end of the year last year, you did a great job of talking about how the pandemic has really affected your court. And the American Bar Association issued Formal Opinion 498 just recently about the virtual practice of law. We're going to have a data privacy panel later in the day, moderated by Chris Dix. I encourage everyone to stick around for that. But you've got all these things going on. You've got the pandemic. You've got a new ABA formal opinion on the virtual practice of law. You are busy people. Nevertheless, how active do you think the judges should be, and what role has cooperation of counsel played in that?
Well, good morning, David. Good to be here. I probably take a little bit of a slightly different bent on things than some of my colleagues. I'm a real proponent of active participation by judges in cases. When the rules were amended in 2015, that was one of the things that was suggested, that judges take more of an active role. Now, of course, you have to balance that. As Judge McCoy pointed out, we all have a number of cases. You can't possibly have hearings all day in every case, so you have to really balance your time. But what I do in a number of cases to actively participate is I encourage the parties to contact me by email. They send what I call a letter brief, because in 95% of discovery motions, there really is not a heavy lift on what is the applicable law. The parties need a decision. door A or door B, particularly in the e-discovery area, and they need a decision quickly. So I have a system set up. The parties will contact me by email. They'll identify in a non-adversarial way the nature of the dispute, and I will schedule either a Zoom conference like we're having now, or simply a telephone conference and rule on the motion quickly, and it tends to move cases along. I remember about a year ago I was at an e-discovery conference and Judge Grimm was there. And during a portion of the conference he was talking only to judges. The participants had left the room, and he began by saying, "Judges, the standard of review of a discovery order is abuse of discretion. You need to rule. You're not going to get reversed." And I'm not making light of that, but it's true that with a vast majority of discovery disputes, what is necessary is a prompt ruling by the court. The other tool that I use, Judge Snead talked about this and Judge McCoy mentioned this, is to schedule in larger cases, not smaller cases, but larger cases, periodic status conferences. And that tends to be a time where any percolating discovery disputes can be addressed. And I find at those conferences, rather than ruling granted or denied on a discovery dispute, we discuss issues and the court provides its perspective on how the parties might approach a particular discovery issue. And by doing that, we avoid, in large part, the parties having to file formal discovery motions. Now, of course, there are those instances where the court needs full briefing on a discovery issue because there is a novel issue of law. And in those instances, you have to handle it primarily in the normal brief, counter brief, and then the court issues a written opinion. But I find that active participation, making the time, I'll do it at lunch, I'll squeeze it in, a 5 to 10 minute phone call really can help to move cases along and really cut off bigger problems that could develop because the parties don't have an answer to a particular question regarding something to do with the discovery process. And then just one last thing I'd like to add. This really isn't necessarily active participation. It has to do with cooperation. And it really is, as Judge Matthewman said, the new paradigm in discovery since 2015, that it's no longer that adversarial system of the requesting party asks for everything and the responding party tries to give nothing. But cooperation is more than just requests to produce and responses to requests to produce. It begins day one with the Rule 26 conference and goes all the way through the discovery process, dealing with protocols, stipulations, and even to the point of trial. And the point of cooperation is there is a direct benefit to your client. You save time, you save money, and you tend to get cases to the issues that really require resolution by a fact finder. So it's a win-win for both sides, and certainly from the court's perspective, it's a win as well.
Thank you, Your Honor. I appreciate that. Judge Barksdale, we have another interesting case in the jurisprudence of questionable cooperation and activist judges. In Azonis v. Suffolk Bus Company, Judge Brown took a different approach than Judge Presnell, and he wrote, "Unfortunately, rock, paper, scissors involves human variables that render it less than ideal as a dispute resolution device. The instant matter may be better resolved, in this court's view, by something else, through the use of coin flipping, a commonly used practice that employs an item manufactured to exacting standards by the United States Mint." Now, clearly, I'm not going to ask you to comment on the jurisprudence of Judge Brown or Judge Presnell specifically, but once again to you, we've got coin flipping, we've got rock, paper, scissors. Where do we draw the line on how active judges should be?
Thanks, David. First, I wanted to ask you, do I get extra credit from Professor Hamilton for wearing my orange and blue scarf? Second, I was hoping for the results of the poll on judicial active involvement because I was going to conform my answer to the majority thoughts. But since we don't have that, I'm going to wing it here. I think it depends on your definition of active. Ideally, a magistrate judge will receive a discovery motion and look at it that very day and do one of two things. Decide the parties haven't sufficiently conferred to try to resolve the issue, or immediately set it for a hearing to talk to the parties about the discovery issue. In doing that, you move the case along fast, and during the hearing, you can identify whether it's one of those rare cases that's going to go downhill fast. I think Judge Matthewman said you have to identify those cases that are going to go out of control and stop it at the outset. There aren't that many of those cases, at least here in the Jacksonville division with our professional lawyers, but there are some, and I think it's important for the magistrate judge to identify those and try to assist as warranted, whether that means setting a status conference every month or creatively thinking of ways to resolve discovery motions otherwise. I think the very best lawyers, and Judge Jones alluded to this, understand that zealous advocacy and cooperation are not diametrically opposite, that they go hand in hand. And those very best lawyers seamlessly apply both. I think of cooperation less as having to give up a valid position and more of conversation between reasonable professionals. And when people can engage in conversations and still convey their points, their valid points, the case moves along fast and inexpensively, and the way it should be, the way the 2015 amendments were designed. On coin flipping and rock, paper, scissors, I like rock, paper, scissors, David. It seems to be less of a chance there.
Thank you very much, Judge Barksdale. Judge Matthewman, you are up next, and we know your views on this. They're published by the Florida Law Review, and for your CLE materials and for general reading, I'd encourage you to read Judge Matthewman's article available at the Florida Law Review, and the responses by Judge Peck, Professor Hamilton, and my response are at the Florida Law Review Forum. So please check out University of Florida, all those resources. Judge, your views on this core component number 10 have been published. We know how you feel about how active judges should be. So I'd like to give you a question we've just had come in from the audience, and that is on the use of special masters. Obviously, they're an important part of the e-discovery process. They're learned experts who have been into the trenches, the nuts and bolts. Many of them have very good technical expertise. Some of them will be speakers later today. Judge, how do special masters impact how you adjudicate cases?
You know, I have not had a lot of use of special masters. I know they have been used, and they can be very helpful if it's a very large case, a very complex case, a case that is going to take an awful lot of time. When I was practicing as a lawyer, I was appointed as a special master in a discovery dispute in a criminal case, and handled it. I think it can be helpful, but I also think that it can also be expensive to the parties. So I think it's going to have to be, if it is utilized, it would have to be utilized in the right case, in a case that's very large, very unwieldy. It has a lot of nuanced issues, a lot of extensive e-discovery, perhaps between two large corporate giants or some large case like that. But I don't, as a routine matter, utilize special masters. I try to handle everything within my own chambers. to get the matters over with as quickly and as inexpensively and promptly as possible. There is a place for special masters, but I think it's somewhat limited to the certain types of cases that it would be appropriate for.
Thank you, Your Honor. We are now ready for a poll question, and this one is going to come up on the screen in front of us. We've done 2 of the core components, and here it is. An e-discovery practice, the problem of requesting everything in the kitchen sink, and replying with boilerplate objections has, and you've got your 3 answers there. And judges, you are prohibited from voting, as am I. We don't get to vote on this one. So we're going to let the audience think about what has happened here. And a lot of this question goes back to the time of the 2015 amendments to the Federal Rules of Civil Procedure. And we'll see how the results come in. They will be coming shortly, popping up on your screen. And while we wait for those, I want to explain, for those of you who have, and I'll tell you what, the results are here. Stayed about the same is our winner. Actually, it's fairly close to a third. Stayed the same, though, has carried the day. And now we'll explain why we are asking this question. For those of you who have read Judge Matthewman's Law Review article, the 10 core components of the new paradigm, we don't have time to do it in 50 minutes. So we've hit 2 of them, but we're taking them out of order. We did number 10 first on active judges, then we did number 5, and that was on cooperation. We're now going to get a bit more granular. And we're going to go now into some of the core components that really affect your daily work, and thus the conference theme, work smarter, not harder. Core component 3 is targeted and precise discovery requests. And in this one, we're going to start off with Judge Jones. And Judge Jones, what would happen if you were asked to referee a dispute where you are getting the typical broad-based, to use the vernacular, overly broad, any and all appears everywhere, documents as defined as to include everything, and the kitchen sink? Judge, what's your reaction to that kind of thing?
That's a real problem, David. And you know, when we talk about the e-discovery process, it really begins with the documents the parties are requesting. And as we all know, under the 2015 amendments, proportionality is now part of the calculus that courts use. And if you find yourself in a discovery dispute early on in the case, and you're before the court, and the court is going to focus on proportionality issues, really the first place the court is going to start is how targeted was the request to produce. And there is still, I'm a little surprised by the results that the poll says things have stayed the same. I think things are getting better. But parties really need to understand that when you craft a discovery request, you need to ask for exactly what you want. For example, let's say you had a case involving a breach of contract with widgets, and loss of profits is going to be an issue. You need to ask the other side for their sales data. So you ask for it. You say, produce your sales data for the Southeast region from 2015 to 2019. The other side understands what that request is asking for. If for some reason that resulted in a discovery dispute, you'd be on very firm ground in telling the court why that's important, why that's proportional to the case. And parties don't realize this with making requests. They always worry about this when they respond. But when you make a request, it is controlled by Rule 26G. And 26G says that when you sign a discovery request or response, you're certifying that there's a good faith or reasonable belief that you are requesting, relevant information. And if you use the practice of requesting everything under the sun and the kitchen sink, it could result in pretty severe sanctions. And there's actually a fairly recent case out of Eastern District of Michigan, EFFYS versus Kelly. And in that case, the plaintiff utilized that sort of scorched earth, any and all, no reference to what was really being requested, no reference to relevance to the case, no reference to a time frame. And the court in that case imposed Rule 26G sanctions. So lawyers need to know that when you craft a discovery request, care must be taken. And you should know by the time you craft your discovery request, you've had a Rule 26 conference, you should have some idea what data the other side has, what their email system is, do they have databases, et cetera, et cetera. So when you're asking for information, you can ask for very targeted and very precise information. So that's probably something that's a work in progress in the profession. I think lawyers are getting better at that. There's a little bit of reluctance to get rid of the 10 pages of boilerplate that begins a discovery request, but I think firms are now starting to see that other than a few small definitions at the beginning, all of the boilerplate is no longer necessary, nor is it really proper to use it in a discovery request.
Thank you, Your Honor. We're having a lot of great questions come in, and unfortunately, there's no way we're going to have time to get to all of them because we're combining these two topics, Core Component 3, which is the targeted and precise discovery requests, and then we've got Core Component 4, which is complete discovery devoid of the boilerplates. And Judge Peck wrote eloquently on that, and Fisher v. Forrest as another wake-up call to the bar. But some of these questions are coming in. There was one member of the audience who loved the idea that Judge Jones brought up of the letter brief or emailing and quick resolutions by Zoom. But the fascinating question is, what about the appellate record? If you do something that is so great for judicial economy, so efficient, gets the case done, but then there's the appellate record. We've got another question that's come in that talks about, do you even bother with the general objections that come up if they're not targeted and precise? So with this, we will check in with Judge Barksdale, pick and choose any of these or anything else you might like to discuss on the issue of targeted requests and then boilerplate responses.
Well, David, I think before you told me I couldn't vote, I was going to vote on stay the same. Or maybe it's slightly better, but just slightly. I see lawyers still using the kitchen sink requests and the boilerplate objections routinely. My theory on this is there's 3 reasons. One, those lawyers haven't read the rules after 2015. I mean, really read the rules really carefully and tried to apply them. Second, they've never revised their forms that have been used by the firm or by partners for a long time, probably very well in the past, and there's just reluctance to change those, either because associates don't have the confidence or for whatever reason. Third, there's of course a fear of committing legal malpractice, of not uncovering something that's important to the claims or defenses, and really waiving an objection. Those are the fears that lawyers have. I will say that it's been 5 years since the 2015 amendments. Judges have been fairly lenient with lawyers in seeing these kitchen sink requests and boilerplate objections, but times are changing. And so I believe that when lawyers continue to use these, they really do run a higher risk of committing legal malpractice and waiving possibly valid objections. And you'll see more and more judges taking a look at those boilerplate objections, those giant general objections in the front, and either sanctioning the party or requiring that party to start over again, which is an expensive endeavor for that party's clients. On boilerplate objections, you'll see more and more often a judge simply saying, you have waived the objection, by not following the rules and doing these boilerplate objections, produce everything they requested as long as it's targeted discovery. So that's what I would say on that. As an old appellate lawyer, I think the question on preserving an appellate issue when you use the discovery letter approach, I think it's a really interesting concern. I think if a lawyer has a valid objection, they need to stick with it, pursue it, keep it on the records, and ensure that they're preserving that. To appeal a magistrate judge's ruling, they have to go to the district judge first and get a ruling from the district judge. And so all of those waiver issues are interesting. In the letter approach, you really are waiving most of your appealable issues if you agree to that approach. But lawyers definitely have to keep that in mind and maintain the record, maintain the objection for appellate purposes if they need to.
Thank you, Your Honor. We've still got Judge Snead and Judge McCoy on this topic. And so you've heard the questions that have come in, Judge Snead. You've got core component 3 on the targeted and precise requests, core component 4 on avoiding those boilerplates. You saw the poll results as well. What do you think in your court? Have you seen improvement on these issues, or do you want to just jump in on some of the questions we've got here?
Absolutely. I agree with Judge Barksdale. It does appear that things have gotten slightly better, in my view, concerning the discovery requests and responses. I would say we're making some progress, and I think lawyers, because they do have that baseline of cooperation and they really do want to move their cases forward, they really are working to sort of shore up their discovery requests and responses. I think in some cases, we really are not seeing exactly what we'd like to see in terms of trimmed down requests and responses, but I do think by and large, lawyers are moving towards being a little bit more efficient and targeted in those requests. In terms of Judge Jones, I do want to echo what he mentioned about the requests for discovery needing to be very specific, very direct. It should be absolutely clear what it is that you are seeking, not just because you want clarity and you want to avoid any objections, but also because it's required by the rules, of course. The requirement is that the discovery does need to be specifically targeted about what you are looking for. And also, we're presuming that you are looking for specific information and documents in those requests, and that we're just going to throw out the idea that you are trying to be uncooperative and you really are trying to request everything under the, including the kitchen sink, to be obstructive. Obviously, that is not allowed, and that is specifically not allowed by the rules. And because I know that you are not trying to do that to the lawyers out there, you need to go towards the side of what Judge Jones was mentioning and what the rules require about being very specific and targeted. And I want to remind you that when you're writing these requests, you're thinking about your case, you're thinking about, all the discovery that you want. Think about when you need to defend those requests or responses before the court. What will the court do? Don't forget, if your opponent objects to this request and you cannot reach a middle ground through compromise about these issues, this will be an issue that will be brought before the court. What will the court say? And I think you need to think about, does that request relate to a specific allegation in your complaint or in your opponent's affirmative defenses? Where is the connection? Because that is a specific question I'm going to be asking. I'm going to have a notebook. I'm going to have your complaint. I want you to point to the specific paragraphs that you are referencing and why it's relevant. So you do need to be very specific. In terms of Judge Barksdale's comments, I also have to say, we really want you to try your case. We want you to litigate from the lawyers your own case. We don't want to be so intrusive that we help take over the direction of your case. And I'm not going to take over the direction of your crafting of your discovery requests and responses. So I don't have a strong objection to you wanting to include all of those boilerplate general objections in your request. It takes a lot of time. It takes your client's money. But if that's how you want to spend it, because you have all of those fears that Judge Barksdale so well explained, include them. But just know we're not going to, generally, I'm not going to pay any attention to them. I would like, if you could, include those specific objections where you have very specific reasons why you are objecting. And of course, all of that needs to be crystallized when you get to the point of having motion practice. I want to know, and I think the judges want to know, specifically why you are objecting to that request. And just know that if you don't include all of those general objections, you'll have an opportunity in those specific objections and in your motion practice to really make the issue crystallized about what your true objections are. Also, I have to say, I do love Judge Barksdale's scarf and can't wait to get one.
There you go. It is a conference tradition. I've got the gator tie. Judge Barksdale's got the scarf. Judge, we will make sure you get one. We are now time for our lightning round of closing comments. We've got to keep them to 30 seconds, but I have failed as a moderator, Judge McCoy, in that I have not given you enough airtime. Judge McCoy, you get 60 seconds. Everybody else gets 30 seconds. Your thoughts, Judge McCoy, on the issues we've discussed today?
Thank you so much. It's been a pleasure being here today. I will just say that I would like to remind everyone that when it comes to electronic discovery and the discovery process generally, I don't think I and my colleagues ever expect perfection. What we expect is effort, reasonable effort, cooperation, civility, and professionalism. So if there's anyone out there in the audience who's not accustomed to the e-discovery space and is feeling very insecure about how to learn these matters and to navigate it, I hope that your takeaway from this judicial panel is that judges understand that not every discovery process is going to be perfect, but there are some baseline expectations you can bring to the table, notwithstanding a lack of technical expertise that are really going to help if you have to bring a discovery issue before the court.
Thank you, Judge Mac McCoy. The Honorable Patricia Barksdale.
Ditto, Judge McCoy. Ditch the forms, read and reread, and then reread again Rules 1 and 26 through 37, including those on e-discovery. And finally, read the Middle District of Florida Discovery Handbook, which is an excellent handbook on how discovery should be conducted appropriately, and it includes information on e-discovery.
Thank you very much, Your Honor. The Honorable Gary Jones. Judge Jones, we don't have your audio, sir. Thank you, sir.
One thing, sorry, that we haven't touched on, and that is, I think it's important, this is an e-discovery conference, to focus on the fact that you need to get your IT people involved. You need to get e-discovery experts involved. It's a whole new landscape out there. In the days of lawyers appearing in court and saying, well, Your Honor, I don't really know how to do that, and I don't know what button to push to get that, those days are long, long gone. So arm yourself with professionals who have expertise in these areas.
Thank you, sir. The 30-second lightning round summation from the Honorable Judy Snead.
I want to thank everyone again for having me. It has been a pleasure to be back here at the University of Florida. I just want to have my closing remarks focus on cooperation. If lawyers really focus on cooperating together, trying to work hand in hand to resolve any of those discovery disputes, I think you will find that your client will be more satisfied with the outcome because the litigation will be less expensive and more quickly resolved. If you aren't able to resolve those issues, go ahead and file your motions to compel or motions for protective order. We're not here to stop you in doing that. We do want to make sure that we encourage you to file those if you need to. If you have not been able to work out your issue, file them so that we can prevent any issues from festering and we can break any log jams in your case and allow you to move forward towards resolving your dispute. But make sure that you work diligently to resolve it before coming before the court.
Thank you, Judge Julie Snead. And the final word from our keynote speaker, the Honorable William Matthewman.
Well, first of all, I just want to say what a great group of colleagues on the panel. I mean, just phenomenal, and I've even learned things today. The second thing is to the lawyers out there, don't forget that the goal in the case is the settlement, the verdict, the summary judgment, the trial. Don't get focused and lost on the e-discovery aspect and have the tail wagging the dog, as I spoke about. Remember, discovery is a means to an end. It's not the goal in and of itself. So if you act professionally, you act reasonably, you're going to get what you need to either prosecute your case or defend your case. You will get that. But just remember the bigger goal. Don't miss the forest for the trees. Look at the bigger goal of what it is you want to achieve. When you start out your case, look at your jury instructions. Remember what it is you have to prove and try to get discovery targeted to what you have to prove in your case.
Thank you, Your Honor. On behalf of our judges, Professor Bill Hamilton, the University of Florida Levin College of Law, and the entire Gator Nation, thanks for starting the day with us. Stay tuned for case law. You've got great programs throughout the day, and I'll turn it back over to Professor Bill Hamilton.
Yes, thank you very much, judicial panel. You all are just wonderful, very informative, very interesting. We're going to take a 10-minute break now, but I did want to say a couple of things. First, we received a huge number of excellent questions from the audience. As you can imagine, with an audience in excess of 1,500 people, we just can't get to all of them during a 55-minute session. The judges have agreed, however, to respond to your questions individually. So what we will do, assuming you put your name on the question, you'll get a response back from the judges or the conference responding to your question. So have the questions coming. We're going to get to them, but we're just limited in terms of our time that we have today. We'll also post some of the materials that were mentioned on the materials and resource section of the website, which you can access with the password that was provided to you in the email yesterday and today to registrants. So with that, we're going to move to our break. We're back at 10 o'clock with our case law panel, and it's going to be exciting. Things are popping out there in e-discovery case law. Stick with us. We'll see you in 10 minutes.